Well, hello, everybody. I think we've got most of the people on. Let me see. I want to wait maybe a couple more seconds. Well, I appreciate everybody being here today. If you were with us a couple weeks ago, we are doing a Back to the Basics series, and the first one that we did was on the Freedom of Information Act, and the next one, doing what we're doing today is Michigan Open Meetings Act. So I wanted to just let you know that we'll be going through an overview of the law, really starting from the basics of it. I will give practice pointers and tips along the way, mainly in areas that I see are most frequently where I see the most frequent problems or the most frequent mistakes. So I'll highlight what those mistakes are so that we can all learn from them and move forward. But if you have any questions, obviously you can use the chat, and I will may be able to do it at the place. Otherwise, we can wait and ask, and I'll be happy after the session to answer any questions that you would have. So the Open Meetings Act, first of all, this is a 1976 statute, and it has been amended, and I'm going to talk about some of the areas that the legislature is looking at right now. But for the most part, it hasn't really changed that much since 1976, and there's some places where it temporarily adapted to some of the new technology. It hasn't done it fully in some places, and so we will point that out. But I think the legislature has done work in modernizing the statute recently, but there's a lot of things, and we'll see them as we go through, that are antiquated maybe at this point, but that are still going to be things that we have to worry about and comply with. So the main part of the Open Meetings Act is that, business of the local government takes place in a place open to the public and held in a place generally available to the public. And we want to make sure to, as a general overview, that we're considering people with disabilities. So one of the practice pointers that we talk about is in any meeting notice, there should be a place where you give the contact information of the person that can address any requests for accommodations, or from anybody attending the meeting or anybody on maybe one of your boards or councils. So we want to make sure, again, that it's openness in government, and that we have the ability to include anyone who would want to attend a public meeting. So what is a public body? Some of it is very obvious. We have a number of different types of public bodies that have signed up for this webinar. So, depending on what your government entity is, you may have different Open Meetings Act requirements, but it's any state or local legislative or governing body, including a board, commission, committee, and subcommittee. And I want to pause about and point out committee or subcommittee that's empowered by a state constitution, statute, charter, ordinance, resolution, or rule to exercise governmental authority or perform a proprietary function. Right now, there is a lot of case law involving what is a public body. It's not involving obvious groups. So, for example, township boards, library boards, city council, city commission, county board of commissioners, ZBAs, planning commissions. Those are all entities that are subject to the Open Meetings Act and are routinely thought of and comply with the Open Meetings Act. The area that's become really not controversial, but there's a lot of case law and a lot of litigation, and there has been for years, is the issue of whether a committee or subcommittee is required to be a public body that is required to comply with the Open Meetings Act apart from the main entity. So, for example, if you are a library board and you have formed a committee to search for a new library director, it's going to be a question of fact of whether that new committee also has to be subject to the Open Meetings Act. If they are making any decisions on behalf of the public body, there's recent case law and a lot of committees involving committees that were used to select and approve marijuana licenses. And basically, if the committee is been delegated or is actually performing a governmental function on behalf of the board. So let's say that the committee, in the case of the library director, interviews all the director candidates, narrows down the scope and presents maybe one or two to the library board. That committee is likely going to be a committee that should be open to the public and comply with the Open Meetings Act. This is one of the areas that it's really specific about the committee. And so it's very hard to discuss here, like whether a particular committee would be subject to the Open Meetings Act or required to be open pursuant to the Open Meetings Act. That's a discussion that you should have with your lawyer about the particular committee. I will tell you, though, that one of the big mistakes I see communities making is that they believe that if it's less than a quorum of their board, so let's say you have a township board and you form a committee and it's less than a quorum of the township board, that automatically is not a committee that's subject to the Open Meetings Act, and that's not accurate. If it's less than a quorum of the board, it won't be a quote unquote township board meeting, but it still may be a committee that should be subject to the Open Meetings Act. So what does that mean? If the committee is subject to the Open Meetings Act, the committee meetings should be noticed. They should have minutes. They should have opportunity for public comment. It's really important that that you identify what are your separate public bodies within your organization, and that you have a decision about whether those should be open to the public or not. If they're purely advisory, and this is typically one that is fact gathering, maybe comes up with a loose recommendation, but delivers all the material to the board or commission making the decision, that may be purely advisory. But again, this is one of the areas I really would like to pause and recommend that you get specific legal help on your particular committee to determine whether it would be subject to the Open Meetings Act. So now that we've discussed what is a public body, what is a meeting? So a meeting that has to be open to the public really has three characteristics. One, a quorum is present. Two, that it's a purpose of deliberating toward or rendering a decision on a matter of public policy. And I highlight deliberating towards because I think another mistake that I see communities making is that they will say, well, it's not a meeting that has to be open to the public because we didn't make any decisions at the meeting. And I see this often with meetings that are described as quote unquote committees of the whole, where the decision isn't made, but a lot of the deliberation about the decision is made. Those types of committees, if you're deliberating towards a decision, you also should be holding those discussions in an open meeting, even if you're not making a final decision on that. And it has to be a matter of public policy. Typically, decisions that you make at your board meetings about contracting, all those types of things are matters of public policy. Again, if there's a question about whether this has to be in an open meeting, it's a good time to contact your lawyer. But I do want to point out that common mistake that I see communities making, where they just decide that if there's no specific decision, that it's not a meeting. The Open Meetings Act does not apply to a conference or informational gathering as long as it's not designed or to circumvent the act. A good example is if you have a quorum of your board or commission attend a session, for example, at your governing conference, like a Michigan Library Association or Michigan Township Association conference. You can all a quorum of your board can sit in a session and listen to the information and not have to be an open meeting. Similarly, you can attend, and there's an AG opinion about listening to governmental concerns, but the difference here is listening and gathering information versus deliberating. And there's one case that I think is a good explanation. The court found that there wasn't a violation of the Open Meetings Act, but in this case, there was a planning commission, which also had a member of the township board on the planning commission, and there were two township board members in the audience. So there's three, which in this fact scenario is a quorum of the board at a planning commission meeting. And the court evaluated whether there was a violation of the Open Meetings Act because there were 3 members out of 5 at the Planning Commission. The court in this case found that there was not because one of the persons sat silently and did not engage in the conversation. The planning commissioner / township board member and one of the members of the audience who was on the township board did. Had the third person joined in that conversation, it could have been a problem because it was noticed as a planning commission meeting and not a township board meeting. So be very careful if you are with a quorum of your board because you don't want to unintentionally violate the Open Meetings Act. So again, planning ahead. If you think it's important that a quorum of your board attend let's say a meeting of another entity, you might consider having a joint meeting or noticing that as a special meeting of your board in the event that deliberations would occur at that meeting. The other area that I see this come up quite a bit is when boards want to have what they call retreats. Team building exercises. It may be that you're going through a very difficult time with your board as far as getting along and working together. It may be that it's an election has just occurred and it's a new board and you want to get together and have these team building exercises. Be very careful because it's often that hard to have these types of activities without discussing some sort of township or library or other municipal business. So for example, if you have a team building session because you guys are not getting along over a very controversial issue, the odds that that issue is not going to come up as part of a discussion and how to work through it are probably very slim. So typically these types of activities, even though they're not official meetings, if you think you could be deliberating towards a decision, that's where you may consider reaching out to your attorney to determine whether you should have an open meeting. As a rule of thumb, it's never a violation to have an open meeting, even where you maybe think it's a question of whether you have to or not. Having it open, for example, in these team buildings is always going to be the safer option from an Open Meetings Act perspective. Obviously, if it's an open meeting, then you're going to have minutes and public comment and all of that. And so that's one of the factors that should go into the discussion about whether it would be worth the risk, for example, to have a team building or other session not be subject to the Open Meetings Act. But that's something, again, we would recommend that you would talk with your attorney about the specific facts at hand in that situation. So I want to talk a little bit about an area that I see is particularly problematic. And we covered it a little bit when we talked about, for those of you who joined us, about with the Freedom of Information Act, because email communication is now becoming a huge part of a lot of FOIA requests. And they're requesting any and all emails between board members. This is where you see at times there are Open Meetings Act violations, Open Meetings Act violations that are incurred in these email conversations. So generally 2 members of a board. So if you have a 5-member board and you have 2 of the 5 members are conversing by email, not an Open Meetings Act concern typically. You're not prohibited from reaching out to a fellow member of the board and discussing an issue. The problem comes with email is that you often lose control over who becomes part of that conversation. So for example, if a 2-person email is then forwarded to a 3rd person and that 3rd person joins in, you as the sender of the email may not have anticipated that the 3rd person will join, but all of a sudden now you have this discussion among a quorum of your board. If you have a 5-member board, 3 people are joining in, now you have a discussion. One of the tips that we have is if you're sending out an email to your board or commission or committee, send it to yourself and blind copy the rest of the committee. That way you cannot just reply to all. If you're blind copied, the reply to all function doesn't work for you. You'd actually have to go and manually input all the email addresses in there. And that's, I think, a check that you can do. It's like a self-check to that people usually say, well, is this something that's going to be a problem if they're actually inputting it and adding people to the conversation versus, accidentally replying to all with their reply. So be very careful with emails. And I think this is important for your board training to have an email policy, in place to prevent OMA violations, and two, to make sure that email communications are being retained according to your municipality's record retention policy. You want to make sure that all of that's being adhered to. Again, I think email is something that obviously in 1976 did not exist, and it was not a concern of the drafters of the Open Meetings Act, but it's something that we have to deal with now. And and texting is the same thing, and texting and emails or other types of electronic communication. Facebook Messenger, all those types of communications could be subject to this same issue if you're not careful and don't act deliberately when communicating electronically. And, we talked about the reply to all, but there's also what we call the round robin issue. And a good example of that is, and it's a case that came out that the court found there to be an improper Open Meetings Act violation. You have to be very careful if you're trying to do something that looks like you're doing it to intentionally avoid the Open Meetings Act. So for example, if you have a 6-member board and you want to discuss some issues, and if you meet with 2 people on one day, 2 people the next day, and 2 people the next day, and start telling these different groups about the conversations and sharing with them the deliberations, that could be what they call an improper round robin, which means that you are meeting with groups that are less than the quorum, but really in a way that you are trying not to have an open meeting, but trying to get the same information you would in an open meeting. Be very careful of those types of tactics. Again, legal counsel should be consulted because you want to make sure that you are not violating the Open Meetings Act. I will stop for a minute and talk about polling. There is a way that you can poll individual board members, and the way that that's done without violating the Open Meetings Act typically is that one person will contact other members of the board to find out where their opinion might be on an issue. One, that person can't share with any other person that they're polling what the other people on your board or commission or council have discussed. So it's basically a one-on-one conversation just to kind of gather where people are. 2, this is not a way to gain consensus through voting. You can't approve a decision through polling. It really is a way just to gain some information. For example, if you wanted to know whether your board should put an agenda item on the board, you may consider contacting each one individually. If you have not gone through the polling process and don't have a good roadmap of how to do it properly, again, this is where you should contact your lawyer to discuss it, because it's one of those areas that has been found to be not a violation of the Open Meetings Act if it's done correctly. If it's not done correctly, it can be a violation of the Open Meetings Act. So you want to be very careful on this front. Again, I want to stress email. This is what I'm seeing more and more. And as I mentioned, when we were talking about Freedom of Information Act, there's nothing worse than getting a FOIA request for emails and looking over the email chains and seeing that there's a potential Open Meetings Act violation, because now it's in writing, it's right there, it's going to be released to the public. So this is one of those things, if you're going to have a takeaway for this session, it's really training for your board to make sure that you are not using email improperly with respect to the Open Meetings Act. So general rules of the meeting. A public body may not place conditions on attendance at the meeting, such as requiring visitors to sign in or provide names. Okay, this is different from the rules of public comment. And I want to talk about this for a minute, because we're going to talk about public comment rules. When you are holding a public meeting, a person has the right to come into your meeting and sit in the back and not be required to take attendance, not be required to say who they are, not be required to state the purpose of that they are there. Especially if you're a small community, and I've been in a lot of meetings where this is true, and you want to make sure that you are complying with this, because I see it as a courtesy issue. And I've been in meetings, especially smaller municipalities, where someone that they don't know will walk in the meeting and they will, oh, can you introduce yourself and let us know why you're here? And it's done I think in a very genuine, wanting to make sure that they feel welcome and that they feel that their needs are being heard. But I think it can unintentionally be an issue if the person wants to attend the meeting anonymously. This is, again, different from the rules of public comment. There are different rules if you want to speak at a public meeting. So this is only generally if you want to attend. There should be no requirements to sign in. Many of you, and we'll get to electronic meetings, currently in the state of Michigan, you cannot meet a public body may not meet electronically. There's a few exceptions that we'll get to in a minute, but it doesn't, that only applies to the actual members of the board. It does not apply to members of the audience. So if you are allowing people to attend and attend your meeting electronically, there should be a way where they can attend and not have to provide their name and their information when they sign in. So that's something that if you're requiring that to sign in, that's something that you should consider whether you want to keep that in place. Again, people should be able to sit anonymously in the office. This is different from the right to speak at the meeting, as I mentioned. One of the big tenets of the Open Meetings Act is that all persons in attendance at a public meeting have the right to address the public body. What this means, and this is a common mistake, and I'm still seeing communities make it, is that you cannot limit the total time of public comment. And I understand why you want to do it. You want to do it because you see 100 people in the audience and you've got a lot of business and you are thinking that you're going to be here till 2 a.m. if all the people speak. So you want to make sure that you don't limit the total time to public comment. So you can't just say it's 30 minutes at the beginning of the meeting and that's the only time you're going to have to speak. If it takes 2.5 hours of public comment, it takes 2.5 hours of public comment. You can have reasonable rules of public comment, and we've been working on ours. We've been adding to ours, given sometimes we see things that happen in an audience that we don't really expect, and so we can make reasonable rules. So, for example, one of the biggest ones that you make is time limits. As long as it's reasonable, time limits are appropriate. And what you're going to see about these is that they should be content neutral. So it doesn't matter, what the subject matter of the comment is, everybody gets 3 minutes. Additional things like asking them for their name and address, this is still considered permissible. Some communities in the interest of privacy don't want to require them to give their address. And that's a decision that the community can make. But I think it is important in a lot of cases to know where they live, at least to know whether they live in your community. So if you are a library board and someone is coming and giving criticism about a book in your collection, it may be important to know whether they're actually a resident of your district or whether they live in a different state. And so I think it's a reasonable requirement. Content neutral regulations. One of them that we've been working with are no signs. Signs have become very disruptive. And you don't want to regulate the sign. You don't want to say no profanity on the sign, or the sign has to say this or it can't say this. What you either really, or some of these rules, you're just going to have to say yes or no. It's no signs or signs. So make sure it's content neutral and not content driven. You can't rely on unwritten rules. So make sure that the rules are in writing and that you have a formal policy in place for your public comment. This is really important because I see, this is one of the areas I see a lot of mistakes being made. You can only remove a board member for a breach of the peace. And a breach of the peace is a seriously disruptive conduct that accuse abusive, disorderly, dangerous, aggressive, or provocative speech or behaviors tending to threaten or incite violence. It goes way beyond what they consider decorum or civil violation. Here's where I see a lot of mistakes being made. One is if someone is standing in front of a board and is critical of the board and they don't like what the board is doing and they're being they might be upset about something that the board's doing. Unless it rises to the level of disorderly, dangerous, or aggressive, you have to let them speak and you can't remove them from the meeting. The rule of thumb really is that they could get up and recite the phone book, or they can get up and say what they like about the government, or the way the city, township, library is governing. And I see it where people don't like that, a personal attack is something that I see. Well, you're not allowed to personally attack a board member. Well, if the comment is how that board member is doing their job, even if it's personal to the board member, it's not something that certainly can be a basis to remove the person or cut off the conversation. I would be very careful if you decide to cut off somebody's speech. And we've seen this, we've seen this all the time in the last maybe year and a half. I see it many times on the news, where someone will attend a school board meeting and they will read from a book that is in the school library. And the board members will cut them off of reading what's in the book. And I think those are the types of things that, unless it's illegal, which is obscenity, or something that constitutes child pornography, most speech is protected speech, and the speech itself should not be cut off unless it's illegal. That is something that you have to be very, very careful about. And so again, this is one of those things that if you have someone that makes comments that you find to be concerning, before you limit their right to speak, I would seek legal counsel on those issues, because most of the stuff, even the stuff that you feel is upsetting, will likely be protected speech. So be careful of that. The right to attend a meeting includes the right to tape record, videotape, and broadcast the public meetings via live radio and television. So this is right from the statute, and this is where I can see that there's an issue with the 1976 environment versus now. Although it doesn't say it, my personal opinion is that means that you have the right to broadcast live on Facebook or other social media platforms. That might be something that is a difference of opinion among some attorneys, so certainly keep this in mind. And that's something you might want to seek legal counsel on from your own personal attorney. But I think people don't like to be recorded, and I understand that. And it might be disconcerting if someone has their phone up recording everything you do. But the Open Meetings Act specifically allows the public to videotape or tape record the meeting and rebroadcast it. It's specifically permitted in the statute. And so that's something that shouldn't be, stopped or taken away from. Now you can limit it. The person doesn't have a right to have the phone, 2 inches from your face during the meeting. You can make them sit in the seats, or you can have other content neutral type of regulations, but they do have the right to record the meeting. As I mentioned before, electronic participation is really only permitted right now to accommodate a board member's absence due to military duty. There have been several, and there's one pending right now. I won't go into detail about the specific nature of it, because there's been a number of different proposals for amendments to the OMA to allow electronic participation. And there's some exceptions for different types of organizations, but because this is a general webinar that pertains to local public bodies, generally in these cases, members can not attend virtually. They have to attend in person. And when I say attend, I mean the right to participate in the meeting. So if, one of the questions I get is, one of our board members is in Florida for the month of February. Can they call in and attend the board meeting, even if they don't vote? The answer is that you can allow them to attend the meeting if they attend in the capacity as any other citizen. So if you allow citizens to participate electronically and the person wants to call in and listen as a citizen, but they can't be counted for the quorum, they can't participate, even if they don't specifically vote, I think allowing them to, call in if they're not allowed, if you don't allow other members of the public could be problematic. I want to mention potentially ADA issues. I think a request for accommodation made by a board member to attend a meeting electronically, for example, should be treated as you would any other request for accommodations under the ADA. So I would process those requests as you would process any other ADA request from a public official. So, notice of the meeting. The notice of the regular meetings must be posted within 10 days after your first meeting of the calendar year or the first meeting of the fiscal year. So make sure that even if you approve the schedule at a different date, that it's posted within those timeframes. And it has to be posted at the principal office stating the dates, times, and places of its regular meetings. A public notice shall also contain the name of the public body, its telephone number, and its address. And I see this as kind of a big mistake, particularly with some special meeting notices. Even though it might be obvious if you're posting a special meeting on the front door of the library or the township hall, what the address is, it's still a requirement, a dot the I, cross the T requirement of the OMA to have that in the notice. It always has to be posted at your principal office. And it may require website posting, which I'll get to in a minute. It also has to be accessible to the public during the time. So if you have, for example, we're going to get to special meeting notices. If it's an 18-hour notice, make sure it's published and it's 24 hours before the meeting. Make sure it's posted on the front door that the public, if they walked up to the building, could see it. If it's on an interior bulletin board, that might not be sufficient. If the public can't see it, then it's not going to be considered published for the appropriate time period that the public weren't able to view it. So make it very easy for the public to see that, and make it sure it's on on either on the front door of your building or within some people have display cases right by the front door for all notices, but make sure it's visible. I want to stop too and pause because I see this as an issue that we've come up against lately about public hearing notices. Okay. There are special requirements for some certain types of public hearings. Some zoning decisions require public hearings. I'll get a good example is a budget hearing requires a certain notice that's published. You have to make sure that you comply with those publication requirements and the Open Meetings Act. So for example, if you're going to have a budget hearing at a special meeting of the public body, you have to make sure not only are the public hearing notices published in time, it has to be published a certain amount of days in the paper before the hearing. But if it's at a meeting, you also have to make sure that that meeting notice is published, is posted according with the Open Meetings Act, because a public hearing really is an agenda item at a meeting. A public hearing is an event that takes place at an open meeting. So you have to make sure, even if it's the only agenda item, that you're complying with the Open Meetings Act with respect to hearings. So you want to reschedule a regular meeting. What the Open Meetings Act, and this is interesting language, I think, it states that if a public body changes its regular meeting schedule, it must post a new notice within 3 days after, and I've highlighted the meeting at which the change was made. And at least 18 hours before the rescheduled regular meeting. this is one of those interesting things because the statute doesn't really state this directly, but you can see from language here, it presumes that a regular meeting decision to reschedule it has to be made at a meeting. So easy case, let's say you set your regular meeting schedule for the year and realize one of your regular meetings is held on an election night. Well, if you want to change that meeting, maybe if it's at the August meeting, maybe at the March meeting, you realize that at that meeting you make a motion to change the regular meeting schedule, and then you have to post that notice within 3 days. If you cancel a regular meeting, for example, because it's the day of the meeting and 3 out of your 5 board members have the flu and can't attend, so there's not going to be a quorum, you cancel the meeting. That change is made really not at a meeting, and so I think typically one of the things you can do then, if you have to have a meeting, is cancel the regular meeting and just post the new meeting as a special meeting. Again, that's something that I would recommend that you get legal counsel on, particularly if you've got issues that you need to address, controversial issues at that meeting. You want to make sure everything is done correctly and that there's no ability to challenge it, because canceling a meeting sometimes gets people upset. They sometimes believe there's a bad motive behind it, and so you want to make sure if a regular meeting is canceled and it's rescheduled that everything is done in accordance with the Open Meetings Act. The OMA does not address any rules for canceling meetings. This has become an issue. I know at times where maybe one board member calls off the meeting and the other board members don't know about it, and so this is something that's a procedure issue that you should discuss within your own community and get your legal counsel involved. Also, sometimes the other area where we see a lot of having to reschedule or change regular meetings is if something happens and you normally have 3 people in the audience and now you have 250 people and they're not going to fit in your township hall. If there'll be a large crowd, you have to anticipate that, maybe move maybe move the location of the meeting. Again, that's something that if you can anticipate it, we definitely recommend that you plan ahead with getting those logistics figured out. So for special meetings and meetings that are recessed more than 36 hours, you have to post a notice at least 18 hours in advance at both the principal place of office and on your website. And the website notification is only required if your official website includes monthly agendas and minutes. Okay, so that's really the standard. And I know that when this was amended, when the OMA was amended to add this, I know that there are some communities that actually took their minutes off and their agendas off, so they didn't have to comply with this. I think, that's going to be a decision that your community has to make. I know that posting your agendas and minutes at times will certainly prevent maybe some Freedom of Information Act requests from coming in for those minutes. So there's maybe logistical reasons of why you would want to do it. But I do point that out that the website publication only applies if you have your agendas and minutes on the website. And that was added in 2012. So it's been there for a while. So you're likely already familiar with it. The one thing I do see still that's a problem is that it has to be the notice has to be on your homepage or a separate web page, accessible through a prominent or conspicuous link on your homepage. So the mistake I see people making is that they post their special meeting notices in your calendar. So if you have a library board calendar, that's not where the special meeting notice should go. It could be there also, but there should be a link on the homepage of your website. It should be on the homepage, or there should be a link that says special meeting notice or special meeting or something that alerts them to where they can find that notice. So if that's not part of your practice now, we recommend that you change that, because I think that's something that certainly would call that meeting subject to challenge. So I want to switch gears and talk about closed sessions. There's some rules and recommendations that that apply to all types of closed sessions. It has to be preceded by a vote in the open session. Use the term closed session and not executive session, and the vote and the purpose of the closed session must be stated and included in the minutes of the open session. I've seen so many minutes that just say motion to approve going into closed session or motion to approve going into executive session. That's not going to be sufficient if challenged. You have to state the purpose and the vote to go into that closed session. At the conclusion of the closed session, you have to take a vote to return to the open meeting, and you reopen the open session of your meeting. So vote to go into closed session, vote back to go into open session to make sure that all the process is done correctly. This is a little confusing, I think, and the legislature has two different processes and procedures for closed sessions, depending on the nature of the closed session. So the first I'm going to talk about is that you can go into closed session for certain reasons by a vote of the majority of the members present at the meeting. So a typical, if you got a quorum, you've got, 5-member board, you've got 5 people there, 3 people, a vote of 3 people will get you into closed session for certain subjects. Based on who signed up for the this webinar, I'm really going to stick to the 2 most prominent ones are to consider dismissal, suspension, discipline, complaints, and evaluations or periodic personnel evaluations of public officers if the named person requests the hearing, or for strategy and negotiation sessions connected with collective bargaining agreements. These are really, for school boards, you can go into also for disciplining a student. So that's for any school boards that are here, that's another way. There's others involving universities as well. But the 2 main ones are I consider them employment related, the discipline, suspension, and complaints, and periodic personnel evaluations, and then the one connected with collective bargaining. You have to be very careful because I've seen some of these closed sessions being used for improper purposes. Now, if you look at, there's very specific purposes. What's not included in there is approval of contracts, discussion of fringe benefits, salaries. Those are the things that can't be discussed in closed session. If the person named has to request the closed session, the minutes should include that the named person specifically approved it. There at least was one case filed because it was a complaint about a board member. The board member was there. The board member voted for the closed session, but never specifically addressed, generally whether they requested the closed hearing, and that ended up becoming the subject matter of litigation. The named person also can withdraw their approval at any point. So either the minutes should state that the person named requested the closed hearing, or you should have that request in writing if the person's not attending the meeting. So certain closed sessions will call a 2/3 roll call vote of the members who are either elected, appointing, and serving. So this is a numbers game. If you have a 7-member board, you need at least 5 members to approve a closed session. So if you have a 7-member board and 4 people show up, you have a quorum, you can conduct business, but you're not going to have the votes to go into closed session. So again, particularly if you are having your attorney travel to the meeting to attend a closed session, you want to make sure that you have the numbers there to do that. So I want to talk to you about some of the purposes that require the 2/3 vote. One is to consider the purchase or lease of real property. Currently, this does not include the sale of property. That is something that the legislature has considered in the past, and so we'll keep watching out for that. But right now, it's the purchase of property, and I think the policy reasons are that if you are purchasing property and you're going to offer as a city $100,000 for the property, you don't want members of the public to know that. and then offer 105 and basically be able to outbid the city in requiring that public property. The theory is also true on the other end, is that if you have a buyer of city property that is willing to pay 100, and it's in the minutes of the meeting that is being offered for the sale of the property, and someone is willing to come in and pay 110, public policy would dictate that that having that in open session might actually benefit the public, because they might get a higher price for the sale of their property versus the purchase. So be careful about that. Also, to discuss with a municipal attorney regarding trial and settlement strategy in connection with specific pending litigation, if it's an open meeting and it would have a detrimental financial effect on the public body. The threat of litigation is not enough. So if you've received a demand letter, that is not enough right now. If a consent judgment has been entered or a settlement has been reached, it's also not a permitted closed session. There is legislation pending right now to allow that to be expanded. We're going to watch that and certainly, let people on our listserv know if that goes through. But right now, it's only specific pending litigation. We always recommend that you include the name of the case within the description of the closed session, because it's important for them to know which case you're talking about when you're using that exemption. Another closed session that requires 2/3 roll call is to review the specific contents of an application for employment or appointment to a public office. If the candidate requests that the application remain confidential, all interviews must be held in the open. This is being used more and more, what we call the application exemption. You should be very cautious of it. And if you're going through, an employment application process, if you're hiring a new city manager, for example, this is something that you should consult your lawyer with before you start the process to make sure it's all done appropriately. First of all, it can't be done if the applicant didn't request confidentiality. So that's a requirement. And if that didn't happen, then you can't discuss it in closed session. It also cannot be used for a reason to compare candidates in closed session. So let's say you have candidate A, B, and C. A common thing you would use is to go into closed session each individually to say, does candidate A meet the requirements? Because obviously a lot of these people have jobs and you don't want to jeopardize their current employment if they're not going to even meet the basic qualifications of the office. So that's a situation where you could look at A, B, and C and say A and B meet the qualifications, C does not. And then C is out of the running and they can maintain their confidentiality. It's not an opportunity to say, okay, we have a candidate A, candidate B. I like candidate A better because of this reason, and to start comparing and contrasting the two candidates. That is not a proper use of this closed session. So again, if you have, and I'm thinking typically if it's an appointment for, a new member, there's been a vacancy and you have to appoint a new member, or if you have to appoint a high level new police chief or new city manager, new library director, this is something that you should review the process before you embark on it to make sure that you're using these exemptions correctly. Also, to discuss material that's exempt by statute. The most common that we see is going into closed session to discuss attorney-client privilege communication. That's because it's exempt under FOIA. And the first one is under FOIA, anything that's exempt under FOIA except the frank communications exemption under the Freedom of Information Act specifically says you can't go into closed session under the Open Meetings Act to discuss these documents, but other ones you can. But it has to be limited to the document itself. So currently, verbal communications by lawyers are not permitted in closed session. So make sure you have a specific attorney-client privileged communication and that only the topics discussed in that communication are discussed in closed session. Anything that involves HIPAA or other medical issues, you can actually go into closed session to discuss closed session minutes. A separate set of minutes has to be kept for the closed session. So when you approve closed session minutes, sometimes what committees do is maybe they'll hand out the minutes, and if there's no discussion, and say to your board or commission or council, can't discuss these in open session, but if you approve the closed session minutes, vote yes. But if people have questions about the closed session minutes, you can actually go into closed session to discuss closed session minutes, because closed session minutes are exempt from disclosure by state or federal statute. For the libraries on there, on the call, the Library Privacy Act is one that is also used. So for example, if you have a patron who has been suspended and that patron files an appeal with your library board, you can go into closed session to discuss any information that's subject to the Library Privacy Act, such as the incident report. For all of these, to be very careful that the motion doesn't disclose anything that you can't disclose. So for example, attorney-client privilege communication, you can say that you're going in to discuss the privileged communication, but you don't necessarily have to reveal the contents, and you should not reveal the contents or anything that would give away the contents of that privileged communication. Similarly, with the Library Privacy Act, that's another example. If you have a patron, you shouldn't say we're going into closed session to discuss, John Doe's incident report. You can refer to it as, patron, appeal 2000 or 2025-1 or something like that, where people know it's a patron appeal, but certainly don't have the name or anything in the motion that would violate the Library Privacy Act. So again, if you don't do a lot of closed sessions and you have any concerns, getting your legal counsel involved in how you should draft the motion and what can be discussed in closed session is important. So the minutes of the meeting must be kept showing time, date, and place of the minutes, and the names of all members present, and a decision made, and all roll call votes taken at the meeting, and the reasons for closed sessions. It's very limited. And so as a rule of thumb, if you are challenged on a decision, the main document the courts will look at in determining the reason and the basis of the decision will be the minutes of the meeting. And so you want to make sure your minutes are substantial enough that if something was challenged, that there's enough information in there to substantiate the decision. I mean, I've seen minutes that are limited to just what's in the Open Meetings Act. I've seen minutes that read basically like verbatim transcripts and everything in between. It's really a matter of taste within the community, so to speak. But again, you want to make sure that it's sufficient enough with the minutes. One thing with public comment, one of the public comment rules that we recommend is to put in the public comment that rules that, the board will, the board has discretion about what goes in the minutes with respect to public comment, and people can't expect their comments to be read verbatim into the minutes, things like that. The decisions made, one of the things that's really important about not only the discussion at the open meeting, but also the minutes, is that some of the harder lawsuits to get rid of are the lawsuits where a decision is made at a meeting and the minutes don't really explain the decision and there wasn't a lot of discussion. So the assumption is that there was a discussion behind closed doors. If you have a very controversial decision within your city and someone attends a city council meeting and nobody at city council takes much time to discuss it, they make a motion to, approve or deny the issue, and then the minutes don't reflect anything. Sometimes there's been lawsuits that have been filed because there's a presumption then that all the discussion took place behind closed doors. So that's another factor to consider when you think of what's appropriate for your minutes. The minutes must be available for public inspection within 8 business days after the meeting at which the minutes were taken. Any correction to the minutes must be made at the next meeting. And I highlight next meeting because if you have a regular meeting, let's say your regular meeting is July 8th today, and your next regular meeting is not until the second week of August. If you have a special meeting between now and that next regular meeting, any corrections to your July 8th meeting must be made at that special meeting. Now, it doesn't mean you can't approve the minutes at a later meeting, but they can't be corrected. And so I want to make sure that you understand that it's at the next meeting and not the next regular meeting. So if you are planning on having a special meeting, make sure that your minutes are available to be reviewed and corrected at that next meeting. Even if it's a special meeting. Approved minutes must be available for public inspection within 5 business days after the meeting at which the minutes were approved. So once the minutes are approved, then those have to be available within 5 business days. So for the minutes, during the closed session, a separate set of minutes must be taken, and they are not available for inspection. These are the closed session minutes. The minutes must be only disclosed if there is a civil action filed under the Open Meetings Act. So, at times we will see a threatened letter from somebody that says, we think you violate the Open Meetings Act. If you give us the closed session minutes, we won't file an Open Meetings Act complaint. Well, unfortunately, the statute says that they can only be disclosed if a civil action is filed and the court has ordered it. So you don't have the right to voluntarily give up closed session minutes absent those situations. So be careful of that. Also be careful with your record keeping that those are kept in a separate place and not available to the public, because I've been given a stack of documents to review in response to a FOIA request, minutes, resolutions, all that, and every once in a while you'll see a closed session minutes in there that's not separated, and they can accidentally be disclosed. So be very careful of how that they're kept and retained within your public body. And they must be retained for at least a year and 1 day after approval of the minutes. Again, the discussion of the closed session minutes may be made in closed session. With respect to the minutes, and this isn't only not only with closed session, but with open session minutes, make sure that they are approved, because oftentimes the statute of limitations or the record retention period starts after approval of the minutes. And so if you don't approve your minutes for 6 months, not only can they not be corrected, but then maybe you are preventing them from being destroyed when they should be, or you're allowing maybe a claim based on those minutes to remain open past what would have been a shorter statutory deadline for filing actions. So you want to make sure that you are very diligent about your minutes and make sure that they're consistently approved promptly. A decision by a public body may be invalidated if a public body is not complied with the Open Meetings Act. And there's only certain, not every violation is going to automatically require something to be invalidated. So, be careful of that. Only certain sections, basically lack of notice, lack of public comment, those are ones that would be a basis for a decision to be overturned. So be very careful of that. The Open Meetings Act basically has a do-over. It's in any case where you fail to comply with the act, you can reenact the disputed decision in conformity with the act. Now, when you're doing this, be careful, because the reenacted decision becomes effective from the date of the reenactment, which is it's a lot of ways to remedy unintended violations. A lot of board members are volunteers. They're not trained in the Open Meetings Act. Most of the Open Meetings Act problems that we see are completely unintentional. And I really like this provision because it allows you basically to do it over. You've been put on notice that you didn't have the right roll call vote for a closed session. Well, if you go into closed session and redo it with the right vote, then it basically, doesn't, then the court says basically that there's not going to be a violation. The problem is with the date of the reenactment. You want to be careful, because if it was something where the date of the original decision was important, maybe it was, approval of millage proposal, and now it's after the deadline, or involves some sort of employment action. You want to make sure that the reenactment and the date of the effective date's not going to put the public body in more, in jeopardy, or in different, create different problems for the public body. So again, this is one of those things where you should seek out the legal counsel. If a public body violates the Open Meetings Act, a person can also basically compel compliance, get an injunction to prevent the public body from further non-compliance with the act. There's a recent case about this. It really has to be it can't, one violation itself or a single violation is not going to rise to the level of an injunction. But I think the court would consider it if, the public body, consistently fails to give proper notice or consistently refuses to allow people to have public comment. So those are the types of things to keep in mind. If you see a pattern within your community that could be a problem, they could also seek injunctive relief from, basically to prevent future violations of the act. There's also an intentional violation of the act. Could be a misdemeanor. So again, most of them are unintentional violations, but if there's a situation where the courts believes that it's an intentional violation, then the person, a board member, could actually be criminally liable. So you want to make sure that you are very careful with how you do the Open Meetings Act, and that you don't know that something's a violation and do it anyway. This is, we don't see this very often, but it's something that we want to point out just to make sure that everybody's on the same page with possible violations. See, so I'm going to stop sharing this because I'm trying to see the comments now. Okay, sorry, my comments had disappeared during the presentation, so I apologize if I, oh, there's lots of them. Okay. Let's see. Okay. John asked if there's a building committee and they have no decision authority, can any board member join that meeting without fear of a quorum rule? I think that's going to be an issue that we talked about with the board meeting. I don't know, John, maybe we can talk about it, after the session, because it's about a specific meeting, but you want to be careful not to have a quorum of if it's a library board, you don't want to have a quorum of the library board attend a building committee, because then it might actually be an unintentional library board meeting. Tony, how about private emails rather than board emails? So the Open Meetings Act is only going to be about deliberations of public policy. So if there's 3 board members that are exchanging emails about going to play golf that night, those aren't going to be something that will be subject to the Open Meetings Act. But if you are using your private phone to text other board members about city business or library business or other public business, then I wouldn't consider those private. Those are likely going to be public conversations that could be considered violations of the Open Meetings Act. So be very careful. So is texting or emailing all board members asking, okay, for informing them that a board packet is ready to pick up? Yeah, one-way communication is fine. And typically we have an email policy that designates one person. Usually it's like a city manager, library director, clerk, secretary. The one-way communication is fine. It's when the people start to write back. So this is a really good example Tina has with the board packet, because if she texts or emails the board, hey, your board packet's ready to pick up, or the board packet's attached to the email, that's fine. But if all of a sudden, a majority of the board members start to email back and say, I don't want this on the agenda. You're bringing up a purchase of a building. I think that's a bad idea. This building location is terrible. Those are the kinds of things that now you're having an email discussion of something that probably should be done in a public meeting. So again, the one-way communication is fine. It's when it's the potential of having that round robin or that reply to all problem. Is it okay for board members to go out after the board meeting and socialize? Yes. Social chance gatherings, social gatherings are specifically permitted under the Open Meetings Act. The issue is, one, you want to make sure that they understand not to talk about business, even at a cocktail party. The second is optics. Now, if you live in a smaller town and you go to the local coffee shop and you're a 5-member board and the 3 of you are sitting in a booth talking, okay, and people are coming and going, they see you there. Sometimes the optics are not good, particularly if the next day they go to a board meeting and there's a decision and it's 3-2, 3-2, the 3 board members that were at the coffee shop were, voted in favor, the other 2 didn't, and there was no discussion. That's where, again, the optics of it, social gatherings, chance gatherings, fine, but just be aware that if there's discussion or if it leads to discussion of public policy or deliberations towards public policy or any board decision, that's where it's going to be very careful. So you want to just make sure that people understand the rules. The board secretary notes the names of all attendees at the meeting. Should I have her stop? I would stop that practice. Again, it obviously hasn't been a problem in the past. I just don't think it's good practice because people should be able to just sit there anonymously. Can you deny them the ability to speak if they're not a resident? No, anybody can speak at a public meeting. Anyone can speak as long as they're the rules. The reason why you can ask them to have their name and address or name and state whether they're a member of your district or your city is because I think it's perfectly appropriate to, weigh or value their opinion based on whether they're a taxpayer or not. Someone that comes in, if I'm traveling through your town, I live in Chicago and I'm traveling through your town on my way to, Mackinac for the weekend, and I stop in and I say, I don't like, the way your park is being run, you might not take my opinion, give it as much weight as maybe residents who pay taxes and use your parks and so forth. So I think it's perfectly appropriate, but you cannot deny them the right to speak. Any person can speak regardless of constituency. Does the library have to provide a video recording? No, there's no requirement that you videotape or record your meetings. This is becoming an issue too, especially with AI and Chat GPT. It's going to become a record retention issue. Right now, from a record retention perspective, you can record a meeting and you can use that tape. Usually, in the past, it's been an audio tape, right? And then the clerk or secretary uses that to create the minutes, and then whatever your record retention schedule says, typically it can be destroyed after the minutes are approved. Those record retention schedules right now don't talk about these recordings really, or many of them, or the AI, the Chat GPT. So you're not required to provide a video recording. And I want to be clear because you're not required to videotape or record a meeting and publish it. If you do it, you want to make sure that one, you're keeping it in conformance with your particular entity's record retention policy, and two, understanding that it may be subject to disclosure under FOIA. So I hope, John, that answered your question. Does the public have a right to come into the township hall and video us working? If you're talking about First Amendment auditors, yes and no. And so you want to be kind of careful about how you do that. We actually have policies in place that talk about public spaces, and it depends on the nature of the space. I mean, obviously not all public spaces are created equally. So do they have a right to come in the lobby and videotape you? Yes. If you are somebody who works the desk, they can sit there and videotape you. Yes, likely. Do they have the right to come into the city manager's office and sit there and videotape you? Likely not, but it depends on the nature of the space. Is it a public space? Is it what is the space open for? Is it open for all uses, or is it only open for specific uses? Just like I can't walk into the FBI office and go into every public space in a federal building. There's different spaces for things. That's something I would talk to your lawyer about, because depending on the space, we have some rules and regulations and Ps in place. Just as a thought, if it's First Amendment auditors, and usually they come in once and they want you to tell them to get out, and they want you to cause a disturbance so that they can put it on YouTube. So that's another factor. Sometimes the answer is just to ignore them and let them do it, because usually they come once and go back. But if you have somebody and there are a lot of people out there right now who just have a real problem with a particular municipality and won't let it go and are videotaping stuff, that's where you get your lawyer involved. See if there's a policy you can adopt that's content neutral, that won't violate any First Amendment rights. But that's something that I think is municipality specific, building specific, and something that you should get your legal counsel involved in. Let's see, allowing public attendance via electronic mode. How do you handle this when people can attend anonymously? Um, I think that's one of those situations, and we had this happen, because a lot of times you make them sign up ahead of time so that they don't, you know, photobomb the meeting, or, that I think was common. I think that's something that you would want to talk with your IT people about, whether there's a way to, do it so that they can protect their anonymity, and you can protect the safety and security of your system. The other thing that you would talk to your lawyer about is, if that's not possible, the risks of requiring the notification versus the risks of protection of public property, and whether it's worth it just to continue with the practice of requiring them to attend. But that's something I think is going to depend on the system and the reasons that you can't do anonymous participation, whether it's going to cause a safety and security issue within your property, which I think you have the right to protect. We no longer offer Zoom and post it on YouTube. We no longer offer Zoom, but our meetings are still recorded. Oh, as long as as long as a person can attend a meeting. So if you videotape your meeting and post it on YouTube, that's fine. As long as, if I'm a citizen and I wanted to give a public comment, I could come to the meeting and give the public comment. You don't have to have they don't have to have the right to give the public comment electronically. You just have to they have to be able to give the public comment at the meeting. And so I hope that's clear in the comment. So it's not, posting it on your website or on YouTube won't make you non-compliant. It's whether you have the ability at the meeting to give public comment and how that was done. Yes, there will be a recording later of the meeting. Let's see. I'm looking, sorry, Craig's got a kind of a long comment. However, they may also wait. Oh, I think what Craig's touching on is the thing I discussed sort of at the end with, and maybe this was before the comment was done, but if you know that something's controversial, and let's just say that you are and I attend a lot of library board meetings about books, and let's just say that you are a library board, and you are deciding on whether a book should remain in the library. And it's very clear under the First Amendment that's a protected book, and I think the board is in consensus that it should stay. If you know there's going to be a discussion or a lot of controversy, I think at times it helps to have a discussion at that it is protected by the First Amendment. Our hands are sort of tied, or another example is with a controversial, maybe a zoning issue, that a variance. We've given out variances like this before. It meets the standards. Be very specific on the record as to why you're doing it, because first of all, if there's a challenge, you created the record, and also if you just go out and make what people think are very controversial decisions without some sort of discussion, it does, I think, beg the question of, well, when did they decide this? They all work at the township hall together on Tuesdays. Is that when they decided it? So if it's out there in the open, and I think this has actually protected some communities that have been sued in the past. There's at least a couple cases when I talk about the committees where things were discussed at a committee level and it was not open to the public, and it should have been. But the court said, look, they had a full and very involved discussion in an open meeting at the board level, and because of that, they didn't find a violation, even though or didn't overturn the decision that was made, even though there might have been an Open Meetings Act violation because of that. So I think there's a lot of reasons why you might not want to do that, and you have to be very careful. For example, if you have a sensitive employment issue, there may be reasons why you wouldn't want to disclose a lot of the stuff in public, and that's again where you can get your lawyer involved to especially with these, maybe a controversial employment decision, to say, hey, is it going to cause us, what can we say in the open that's not going to cause us problems on the employment front, and how do we, balance those two issues? Let's see, should the reasons leading to a policy recommendation during a closed session meeting of a subcommittee be So decisions can't be made in closed session. They can only be made in an open session. And so I guess I'm gonna have to have a little bit more, clarity on that question. That related question, Craig, I can follow up with you if you want. Is there an issue with the closed sessions discussing salary as part of it? Yeah, I think salary is not part of their evaluation. Their evaluation is their evaluation. And if their evaluation is positive, then that leads to salary discussions. I think that's where communities get into, sometimes gets into a problem because they use it that way, but I think it's problematic. Again, if you want to talk to your lawyer about the specific issues with that, I think that's appropriate, but I think it's very, it can lead to problems, I think, because salary discussion should not be part of the closed session. How much should you say in closed session minutes? Well, decisions can't be made in closed session, so there's no vote that's taken, or there shouldn't be a vote that's taken. And so, for example, if you go into closed session my recommendation typically is if you go into closed session to discuss a legal opinion, typically the closed session minutes just say, discussion of attached legal opinion, and you attach the legal opinion to the closed session minutes. A lot of this stuff, I could give an hour and a half or 2 hours on closed sessions alone. So here we're just kind of covering the basics. So some of this might be, appropriate to have discussions about with your lawyer, but in closed session, the minutes should just state enough and make sure that you are clear as to what you're doing. If it's, discussion about the purchase of property, giving enough details about what the board thought so that you can go back to the minutes and understand them. Do draft minutes have to be posted on the website within 8 days so they can wait? It just says they have to be available for public inspection. They don't necessarily have to be published 8 business days, but if someone wanted a copy on business day 9, they have to be available for you to send to them. But they don't have to be posted on your website. Does that include non-quorum committee minutes? So, if a committee, even if it's not I'll give you a good example. If you have a committee, a township board forms a committee, we'll call it the Township Manager Search Committee. You have to decide whether that Township Manager Search Committee is open to the public and should be open to the public. If so, if those discussions should be open, that Township Manager Search Committee should be the public body, and it should have its own set of minutes. And so the committee itself should do the minutes, but they're not going to be quote unquote township board minutes in that scenario. So I hope that's clear. If that's not clear, please let me know. Yes, you can require participants to state their name and address if you have a written public policy, and we recommend that you have it in writing. But yes, for Jessica's question, that you can require them to do that before they can state their name in public. In practice, it's kind of awkward. I saw one recently where someone gave their name, but they refused to state where their address was because they were fearful. And so in those cases, the next question would be discussing with your lawyer. Well, what if someone refuses to give it? What's the next action? Because sometimes people just let them continue to participate. Others may refuse to allow them to do the comment. I certainly think it is an acceptable requirement. If minutes are corrected after the draft was posted on the website, do the corrected minutes that have to be posted to replace draft minutes? Oh, so corrected minutes have to have, and it was in the slide, both the original and then it has to show what the corrections are. And so you would, in your final minutes, it would show what the corrections were from the draft minutes. Again, these don't have to be legally posted on your website. So the issue is whether they would have to be, but if you post them, I would continue that process and I would post the corrected minutes that show like a strike through or an addition or track changes or however you want to do it. But that's the requirements of the Open Meetings Act. During board member comment period on our agenda, if you read from your notes, are those required to be posted or available with FOIA? I would think if someone asked for a copy of those notes and you had them, notes are kind of careful, and I guess I want to qualify this a little bit. If you are using notes that are for your own personal recollection or reflection, maybe not. But if you're reading verbatim from something into the record at a meeting, you're a board member, likely that's going to be subject to FOIA. It's really going to depend on the actual how the notes are done, but that's something that could be subject to FOIA, and that I would certainly have your board member, if there's a FOIA request for that, provide those to you, and you can evaluate whether they meet the definition of public record under FOIA. There's nothing in OMA about approval of closed session minutes. Yes, but it talks about approval of the minutes, and closed session minutes are minutes. So we take the position that they should be approved. Other lawyers might feel differently, so that's something you can discuss with your own lawyer, but we take the position that closed session minutes have to be approved. If you are posting a recording of a meeting on YouTube and the website a day or two after the meeting takes place, does that count as having minutes on the website? No, the minutes of YouTube video is not the minutes. The minutes are the minutes. And so I would have those done the same way you do all of them. What accommodations do we need to have available for an ADA compliance at meetings? That's going to depend on what they're asking for, and there's a lot that goes into the ADA, and whether the accommodation that's a whole different thing, because for example, if what the accommodation they're asking for is going to cost half of your municipal budget for the year, you're not going to have that. But for example, if you have a transcript, if you have it recorded and there's a transcript of it, and that's an accommodation because they can't hear but they can read, that might be something that you would have to do. So what accommodations you need to have available will be something that read the ADA request, what they're requesting, and then figure out if you have the technology to do it electronically. It could be a signer, it could be providing a written transcript, it could be a number of things depending on the request. So it's really hard to say what you're required to have. It's going to be and how much is it going to affect like your budget. There's a standard in the ADA that talks about that. So that's something that if you get a request for that, reach out to your lawyer and figure out what the accommodations have to be in that particular instance. For providing minutes 5 days after vote, except they'll print the minutes off for patrons. Yeah, they just have to be available. And someone can come in and request the minutes, but they just have to be available. They don't have to be instantly available, in my opinion, but they do have to be available. If you have them posted on the website, usually, posting them within the 5 business days after on the website is probably the easiest thing for you to get in the habit of doing. A meeting about building and cyber protocols should be exempt. Yes, because under the Freedom of Information Act, there's an exemption for safety, security, and cybersecurity. So as long as you're talking about documents, those can be exempt under the OMA exemption is that anything that's exempt by statute, and that would be exempt by statute. With a board of 7, can 3 members meet and possibly discuss agenda items? Yeah, it's less than a quorum of your board. And so they could meet typically without problem because it's less than a quorum, but be careful if you're involving other people, or then those 3 people go and discuss things with others. So a city has asked the board review application for each trustee. If the applicant has a meeting, the board going to closed session to discuss who to recommend. No, unfortunately you can't. You can't go into closed session to discuss that. It's awkward, but you have to have the discussion in front of the person. I mean, sometimes you also can't ask. You also can't ask a person to leave the meeting. So it's one of those things that it's part of the cost of doing business in a public body is that you sometimes are subjected to embarrassment. Now, at times people are courteous, for example, if you are a vendor and you're going for an RFP and they're going to be discussing you typically leave the room voluntarily because you don't want to put them in a position where they feel uncomfortable. and your people may do that voluntarily, but those discussions have to take place in an open meeting and you can't ask them to leave. I think the typo, if someone corrects a typo during the approval of the minutes, can the typo be corrected? Do we have to show the correction? I would probably show the correction anyway. I really haven't looked into that too much, so it probably depend on what the typo is, but I guess it doesn't hurt to show the correction. How can we return to open session if we can't take votes in closed session? Let's see. That's a really good question. We typically just move out of the closed session part of the meeting, come back to where we are and make a motion to open the closed session. That's just a common procedure that we do. Again, some lawyers might just think reconvening is fine, but we usually, if we're adjourning to a different room, we come back to the room, make a motion to open back into open session and go from there. The decisions I was talking about in closed session are substantive decisions, for example, decisions to fire somebody or decisions to, act in, like a decision to, do anything in public policy, maybe in response to a legal opinion. Those should all be done in the open session, but making the motion to go back into open session, typically that's just how we handle it. So is there ever a time with an employee requests a closed session that's not acceptable to grant it? So yes, you can only go into closed session if the employee asks for that, but you don't have to grant it. And again, this is one of those things where you should get your legal counsel involved if it's an employment action as to whether you should grant it or not. There may be reasons why you don't want it in closed session. There may be reasons why, even if let's say everyone's really mad and they want everyone to know what happened, why it's better to have it in closed session. So yes, the board always has the authority to decide whether to go in closed session or not. You don't have to go into closed session, but that's something that you should consult with your employment counsel on before you make that decision. Let's see. I think I answered that other question. Different space for closed session. Should the board be moving to a different space for closed session or the public attendance living room? When possible, I think it's better to adjourn to a separate space. There's, depending on like making people like leave or stand outside. Sometimes there's glass windows, you can see into the room. I think there's no right or wrong answer. I think it's just when possible, I think it's better to move to a different session and let the public stay in their seats, and it's more comfortable for them. That's another sort of tip I just want to leave with public comment that I forgot to mention before about the public too and attending the meetings, because a lot of them, that's why you sometimes have the closed session at the end, because people then won't stay after the closed session. But, if you're kind of debating about when you should have public comment, you only have to have it once per meeting. And I typically recommend it at the beginning of the meeting, because one, they can get their comment in before any decisions made if it's about an agenda item. And then let's just say it's not about an agenda item. Making someone wait 3 hours, through a long city council meeting to give their comment about how they don't like their garbage pickup, it can be very frustrating and make them angry, or they're already angry. So that's just one kind of thing to consider when you're talking about accommodating the public and making them comfortable, allowing them to sit there if it's all possible. I think it's more of a comfort thing. I think it's just better practice. So I think that is the end of the comments. I appreciate all the comments and the time. And if there's any questions or something that you weren't clear on, please shoot me an email. I'm happy to answer those questions.